of Ladakh in view of Article 3A, read with Explanation 1, which permits forming a union territory by separation of a territory from any state. And we direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible.
So I begin from a different way from the history of Kashmir. Traced out the history of Kashmir relying on the contextual text of Rajtarangni and Bamzai's on culture and political history of Kashmir. Thereafter, I proceeded to analyze the circumstances in which Jammu and Kashmir Constitution Act of 1939 came into being, and then considered the submissions under different heads. Read out my conclusion. More or less, the conclusions are same, except in one of the aspects of Premnath Kaul's case, I have taken a slightly different route. That's all. So, the relationship between Union and State of Jammu and Kashmir, the concept of internal sovereignty after the IO. I am of the view that this question has been decided by the coordinate bench of this court in Premnath Kaul that the state did not lose all semblance of its internal sovereignty, which would include deciding upon the forms of government of the state upon signing of the IO. The distinguishing feature as compared to the other states was that a slightly different path was followed for the accession of state of Jammu and Kashmir by recognizing the Constituent Assembly to be formed for the state. The route of assimilation of state of Jammu and Kashmir was through Article 370. Then I've heard that I've taken note of the various factors such as Article 370's historical context in the text and subsequent practice to conclude that Article 370 was intended to be a temporary provision. As a corollary, there was a mechanism to bring the whole arrangement to an end. The effect of the power under Article 373, once exercised, would be that the article shall cease to be operative. In other words, the mechanism was meant to de-recognize the state's internal sovereignty. Thus, the exercise of power under Article 373 meant that for purposes of the Constitution of India, only the Constitution of India would apply to the Jammu and Kashmir and not any other constitution, that is the Constitution of Jammu and Kashmir. The purpose, then on Article 373, I have said, the purpose of the Constituent Assembly was to draft a constitution for the governance of the state. On the other hand, the purpose of Article 370, as noted above, was to slowly bring Jammu and Kashmir on par with the states in India. It can hardly be contended that the second and in some ways a larger purpose would be effected by the fulfillment of the first. The second purpose remained an ongoing exercise long after the State Constituent Assembly was dissolved. Thus, the conditionality in Article 373 of the requirement of a recommendation from Constituent Assembly cannot be read in the manner as to make the reference to the larger intention of the provision redundant. B. The next question is to determine what process is to be followed by the President to exercise the power under Article 373. The President can exercise this power under Subclause 3 without a recommendation from the Jammu and Kashmir Constituent Assembly. When the Constituent Assembly ceased to exist, only the power of the Constituent Assembly to make the recommendation cease to exist. That is, the proviso to Article 370 became odious. The main provision, which is the President's power to issue a declaration, continues to exist. C. Now coming to the impugned action, first the amendment of Article 373 through the route of Article 367 was invalid. When a methodology has been provided, that methodology would have to be followed and an amendment through the back door would be impossible. D. Concurrence with the government of the state was not necessary to apply all provisions of the Constitution of India to the state. Although Article 371D requires concurrence with government of the state, in this case, the governor of the state had dissolved the Legislative Assembly of the state. There were no Council of Ministers, and the President had reduced to himself all functions of the government of the state under the 2018 proclamation as extended. Then on the exercise of power under Article 356 were permissible while issuing COs 272 and 273. Article 356 can be imposed once the Legislative Assembly has been dissolved, particularly since Section 92 of the Jammu and Kashmir Constitution limited the governor's role to 6 months without any scope to extend. This imposition was predicated on the failure of the constitutional machinery, which really took place prior to the government's rules. Then B, Article 356 permits the President to make irreversible changes. Both Savan J and Reddy J and S.R. Momai recognize that irreversible actions in this case, the de-operationalization of Article 370 is permitted if the proclamation had been approved by the Parliament prior to such irreversible action. C, the President reserves both legislative and non-legislative powers after the proclamation of emergency. Though Article 356 is continuance of Article 356, the former does not stipulate any bar or restriction on the Union Parliament or the President to exercise non-legislative power of the state legislature. And I've dealt with the challenge to Section 3 and 4 of the Jammu and Kashmir Reorganization Act. A, the challenge to Section 3 of the Jammu and Kashmir Reorganization Act on the touchstone of Article 3 is not required to be debated on account of the assurance on behalf of the Government of India that statehood of Jammu and Kashmir would be restored on elections being held. B, it is imperative to ascertain the views of the state legislature under the first proviso to Article 3 if the proposed bill affects the area, boundaries or name of the state. However, in the instance case, since state of Jammu and Kashmir was under President's rule and the state legislature was already dissolved, the functions of the state legislature were performed by the Union Parliament. Hence, it was not possible to ascertain the views of the state legislature. It follows that Section 3 of the Reorganization Act is valid. I have penned down an epilogue at the end of the judgment, maybe some sentiments involved. The Valley of Kashmir carries a historical burden. It has a social context. Thus, in involving constitutional status of the region, it is difficult to segregate the aforesaid. We, the people of Jammu and Kashmir, are at the heart of the debate. They have carried the burden of victims of conflict for several decades, originating from 1947 with the invasion of the Valley. Intervening political circumstances did not permit a redressal to the fullest extent of the invasion. The consequences remain in terms of parts of Kashmir being occupied by other countries. The second round of insurgency holds its origin to the latter part of 1980s. There were troubled situation at the ground level, which was apparently not redressed. It culminated in the migration of one part of the population of the state in 1989-90. It is something that our country has had to live with, and without any redressal for the people who had to leave their homes and hearth. It was not a voluntary migration. The situation became so aggravated that the very integrity and sovereignty of our country was endangered, and the army had to be called in. Armies are meant to fight battles with enemies of the state and not really to control the law and order situation within the state. But then these were peculiar times. The entry of the army created its own ground realities in their endeavor to preserve the integrity of the state and the nation against foreign incursions. The men, women, and children of the state have paid a heavy price. During my travels home over the years, I have absorbed that the social fabric waning and the consequences of intergenerational trauma on the already fractured society. I cannot help but feel anguish for what the people of the region have experienced, and I am constrained to write this epilogue. In order to move forward, the wounds need healing. What is at stake is not simply preventing the recurrence of injustice, but the burden of restoring the region's social fabric to what it historically has been based: coexistence, tolerance, and mutual respect. It is worth noting that even the partition of India in 1947 did not impair Jammu and Kashmir communal and social harmony. In this context, Mahatma Gandhi is famously quoted to have said that Kashmir was a ray of hope for humanity. The first step towards this is to achieve a collective understanding of the human rights violations perpetuated both by state and non-state actors against the people of this region. There have been numerous reports documenting these incidents over the years. Yet, what is lacking is a commonly accepted narrative of what has happened, or in other words, a collective telling of the truth. Internationally, the right of victims of human rights violation and the truth is an end itself. It encompasses a structural investigation of the events and social political structures that led to the atrocity, the particular circumstances of individual suffering, and an authoritative reporting of the results of the investigation. Additionally, truth telling provides an opportunity for victims to narrate their stories, which facilitates an acknowledgement from those responsible for perpetuating the wrongs and from the society as a whole. This paves the way for reconciliation. While there are different ways of achieving these objectives, Truth and Reconciliation Commissions have been particularly effective globally. South Africa Truth and Reconciliation Commission was set up to investigate human rights violations perpetuated during the period of apartheid regime. It served as a means of reckoning or a catharsis for victims and fostered peace building. Reflecting on its success, Albie Sachs J. noticed, as a result of the TRC, the private sorrow and grief of tens of thousands was publicly acknowledged to an embracing and personalized way. Another form of acknowledgement emerged from perpetrators themselves. They had to come forward openly in front of the television cameras, owning up their crimes. Finally, there was acknowledgement by the whole country that these things have happened and can happen again, that we needed to fit all these facts together in some kind of significant pattern, which would enable us to understand their genesis and do what we could do to minimize any possibility of their reoccurrence. In the past, calls for setting up of Truth and Reconciliation Commissions have also been echoed by different sections of the Valley. In view of the inroads made globally and indigenous requests for truth and reconciliation, I recommend the setting up of an impartial Truth and Reconciliation Commission. The Commission will investigate and report on the violation of human rights both by the state and non-state actors perpetrated in the Jammu and Kashmir at least since 1980s and recommend measures for reconciliation. The Commission should be set up expeditiously before memory escapes. The exercise should be time-bound. There is already an entire generation of youth that has grown up with a feeling of distrust, and it is to them that we owe the greatest day of reparation. At the same time, considering the significance of the matter and under sensitivities involved, it is my view that it is for the government to devise the manner in which it should be set up and to determine the best way forward for the Commission. I am alive to the challenges of recommending of the setting up of the Truth and Reconciliation is beyond the realm of the court. However, I am of the view that transitional justice and its constituents are facets of transformative constitutionalism. Globally, constitutionalism has evolved to encompass responsibility of both state and non-state actors with respect to human rights violations. This includes the duty to take reasonable steps to carry out investigation of violations. It is this context that the proposed Truth and Reconciliation Commission accords with constitutionalism. Our Constitution is no different and is designed to ensure that courts offer justice in situations where fundamental rights have been violated. In doing justice historically, our courts have been sensitive to the social demands of our polity and have offered flexible remedies. In Vishaka and others versus the state of Rajasthan, this court issued guidelines to address the workplace sexual harassment in the absence of an enacted law, which operated until the Parliament enacted the Sexual Harassment of Women Act. As a word of caution, the Commission, once constituted, should not turn into a criminal court and must instead follow a humanized and a personalized process, enabling people to share what they have been through uninhibitedly. It should be based on a dialogue, allowing for different viewpoints and inputs from all sides. In this context of South Africa's Truth and Reconciliation Commissions, Albie Sachs observed, "Judges do not cry. Archbishop Tutu cried. It was not a court of law in the sense of an austere institution making a highly formalized finding. It was an intensely human and personalized body there to hear in an appropriately dignified setting up what people had been through. There were comforters sitting next to the witnesses. In a court of law, no one is there to help the witness, to pat the shoulder or provide water or tissues when the person weeps. Frequently, the sessions would start with a song in a beautiful African harmony, intended to give a sense of encouragement and support to everybody present. Or it could begin with prayers, and therefore people spoke and spoke in all regions and in all languages of the country. The testimony was televised, and thus the nation became witness to what has happened and heard the stories directly from the mouths of persons concerned. Those who spoke were not complainants in court denouncing accused persons in the dock, nor were the litigants demanding damages for themselves, so that the greater the loss, the greater the sum would be received. Taking a leaf out of the South African book, The Principle of Ubuntu, or The Art of Humanity and Inclusiveness should be central to the process. This will facilitate a reparative approach that enables forgiveness for the wounds of the past and forms the basis of achieving a shared national identity. Needless to say, the Commission is only one of the many avenues towards the goal of systematic reforms. It is my sincere hope that much will be achieved when Kashmir opens their hearts to embracing the past and facilitating the people who were compelled to migrate to come back with dignity. Whatever has been, but the future is ours to see. Okay, then.
A judgment is a decision which gives reasons to arrive at and reach a conclusion. By that stretch, my order is not a judgment. We have only two judgments. Both judgments are in seritum, and seritum and uniformly agree that Article 370 of the Constitution of India was a feature of asymmetric federalism and not sovereignty. Article 370 was enacted as a temporary provision and did not have a permanent character. The abrogation of Article 370 does not negate the federal structure, as citizens living in Jammu and Kashmir do and will enjoy the same status and rights as given to citizens residing in other parts of the country. Paragraph 2 of CO 272, by which Article 370 was amended by taking recourse to Article 367, is ultra vires and bad in law, albeit it can be sustained in view of corresponding power under Article 371D. More importantly, Article 370 has been made inoperative in terms of Clause 3 to Article 370. Lastly, CO 373 is valid. I have agreed with what Justice Chandrachud has said, Chief Justice has said with regard to Article 356 of the Constitution of India. I have also made reference to Rameshwar Prasad and others versus Union of India and others, with which I respectfully agree. I also agree with the conclusions recorded by Dr. Territory of Jammu and Kashmir while upholding creation of Union Territory of Ladakh. Then I have agreed with Justice Kaul with regard to interpretation on Article 370, Clause 3.
कारोबार करता है। तो इसलिए हम बहुत खुश हैं कि आर्टिकल 370 रिवोक हुआ। हम बहुत खुश हैं कि इससे जो है यहाँ पे